Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
This is Andrew with O'Flaherty Law. In this article, we ask the question, can a creditor go after non-probate assets? It will serve as an introduction to the topic of creditors' access in regards to non-probate assets. For more information on the probate process, visit Learn About Law. So, when a family member dies and the appropriate relatives begin to go through the probate process, it's normal to have a lot of questions, right? So, confusion over first steps, what comes next, and what the process entails can increase stress during an already stressful time. One question that can arise if the deceased person owed debt, often in the form of credit card debt, is whether the close relatives are personally responsible for that debt. It's not uncommon for the creditors to begin calling family members in an effort to collect on the deceased person's debt. Other questions that may arise include things like what happens to the deceased person's mortgage. If money is left to a family member, can he or she collect regardless of debt owed by the deceased? Can a creditor go after the debtor's non-probate assets or other family members' assets? So let's briefly review what is considered probate and non-probate assets. So probate assets can be considered pretty much anything directly in or under the descendants, that's the deceased person's name. So think like bank accounts, cars, property, etc. that are not designated to a beneficiary or heir within a trust or will. And non-probate assets are those held with a beneficiary designation, think like a mother designated her spouse or child or whatever to receive XYZ within her trust or held as joint tenants, like in the case of a jointly owned property. When would a creditor not go after non-probate assets? Well, creditors do have the right to file a claim against an estate in an effort to collect payment to pay off all or some of a debt. In this situation, probate assets would be used first in order to pay off any outstanding debt prior to the heirs receiving the remaining probate assets. For example, if John died and had $200,000 in debt and had $300,000 in probate assets, $200,000 would go towards paying off the debt with $100,000 remaining, and there would be no real need for the creditor to go after, the non-probate assets. So when might a creditor go after non-probate assets, and what rights do the creditors have? Well, as stated before, creditors have the right to file a claim against an estate to pay off the decedent's debt, right? So even if money is distributed to the heirs before the collection of the probate assets against the deceased debts, a claim can still be filed by the collectors to regain the money and pay off the debt. In this situation, the claim would be against either the heirs or the estate executor or personal representative. But what if the amount of debt exceeds the deceased person's assets? Well, a creditor can look into non-probate assets, which is a common occurrence if there's any indication that the decedent's estate was large, or if it's believed that the deceased person moved money around to avoid paying debt. A simple example of this would be the deceased person putting a large sum of money, let's say $150,000, into a joint held account, bank account before dying. The creditor can still file a claim and ask that some or all of that transferred money be used to pay off the debt. As always, for more information on creditors' claims against entities such as trusts, retirement accounts, and more, visit Learn About Law. Thanks for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com. Call us at 630-324-6666 for a free consultation.